Welcome to the DisabiliTEA, a podcast where we have candid discussions about all things related to disability. Short-term, long-term, financial claims, impact on other areas of life, causes in the workplace, and more. With your host, attorney Anjel Burgess. You can find this show at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Now here's the host of the DisabiliTEA, Anjel Burgess.
Hello, and welcome to the DisabiliTEA. Today we are so excited to have with us an estate planning expert, attorney Sarah Watchko from the law firm of Hill and Watchko. Welcome.
Thank you. I appreciate the opportunity to be here today.
Well, we are so excited to learn. We've got so many questions, so I want to just jump right into things and ask you, just tell us a little bit about yourself and your practice.
Sure, absolutely. So I am an attorney here in the metro Atlanta area, and I've been practicing in this field for, I think it's been about 14 years now. I'm a local. I grew up in the Atlanta area, went to law school, undergrad in law school in the Carolinas, and graduated in 2008 and headed back home. So I've been engaged in this sort of work since then.
Wonderful. So what is estate planning? We hear that term all the time, but not exactly sure what it means. Can you explain that to us?
Yeah, I always feel like when I meet people in the wild and they ask what I do, or they'll say, you're an attorney, what type of law do you practice? I say estate planning. And they're like, yeah, okay. Like they don't really understand what it means
Right.
until you break it down into its parts, which are things that people are more familiar with. Essentially, estate planning revolves around getting documents in place in the case of one's passing away or incapacity. So the terms then become familiar. We're talking about last will and testament, wills, trusts, powers of attorney, advance directives for healthcare. So essentially we're spending time sitting down and talking about these scenarios that can be difficult to deal with, but we're engaging in planning to make sure that we have as many bases covered as possible should the worst happen.
Okay. Well, that makes sense. I definitely recognize a lot of those terms, especially like wills and trusts. So with kind of the state of the world right now, I mean, we are just kind of coming out of COVID, depending on who you ask. How has COVID and this pandemic, how has that affected, estate planning and people's intentions?
Sure. COVID was an interesting phenomenon in a myriad of ways, but certainly in our practice, like a lot of business owners during that time, March of 2020, when everything shut down, we thought, oh, geez, like if we can't have people coming into our office to meet with us, are we going to have clients? And so like most other people, we quickly learned what Zoom was and created our own accounts and got online. And what we found, unfortunately, I mean, it's good that people are doing good planning, but unfortunately, COVID was a reminder that regardless of what age you are, regardless of your health condition, things happen. And if we don't plan for them, then it looks really ugly. And individuals who are younger are less likely, not surprisingly, to have an estate plan in place, to have a will, to have a power of attorney, to have a healthcare directive, because we don't think that it's going to happen. We don't think that it's likely. So COVID in terms of our practice really seemed to be a reminder that regardless of how old you are, regardless of how wealthy you are, regardless of how healthy you are, you can do a giant service to your loved ones, to your family, with this pretty straightforward planning.
Okay. And, kind of speaking of age, we are also at this point in time now where we're seeing a lot of baby boomers that are, aging out of the workforce. So what are some of the issues that you see that families are facing now as they're dealing with their aging loved ones?
Sure. We see all sorts of things. I kind of think of my estate planning clients, individuals and families we help. They come in different buckets. So it's not uncommon for us to do planning for a young family. You've gotten married, you've just had your kids. You don't really know how it all works, but you need a will. You need to name a guardian for your children, your minor children, something happens. So we get a fair amount of families doing that sort of planning, and then it's kind of a forget about it. Like, okay, we're going to shove it in the cabinet. We're not going to think about it again until some other major life change happens. And often that major life change is what you're describing. It's those retirement years where folks kind of have the opportunity to slow down and to reevaluate financially and otherwise the next phases. And that's when people will pull out that will from 1992 and say, oh, we've got, great Aunt Jenny as the guardian, and our kids are now in their 30s. And we've got, we've got Uncle Mark as trustee, and he's not doing so well anymore. So people will start to realize, and that's a major issue that we see in estate planning, is documents that haven't been appropriately updated. So people will start to realize, oh, shoot, it's time to transition here. We're talking to a lot of families, individuals and families who are in what we call the sandwich generation. So they are still taking care of their own children, getting their children grown through college on their own feet financially, as their own parents are fading and needing more hands-on assistance and care. So it's not uncommon for our planning to relate to an individual or couple, and also their own parents who are facing more direct issues kind of at that time in their life when they're not able to manage things for themselves anymore. So the baby boomers, I think, are defined as those born between 1946 and 64. So that would make, if my math is correct, that would make our oldest boomers 76, turning 76 this year. So it's the largest, what I've heard anecdotally, the largest transition of wealth, generational transition of wealth in human history, as the baby boomers age and their wealth shifts down. And that can mean a whole myriad of things in terms of how that plays into family dynamics. Unfortunately, financial abuse and elder abuse is on the rise, and that is a very vulnerable population. If you've got a higher risk of cognitive decline, and also the vast amount of American wealth in your pocket, then you're unfortunately a great target. So our planning often revolves around, well, it can revolve around any of these things. It's when we meet with an individual or family, the first thing we want to do is get to know them, what challenges they're facing, what's important to them. So planning to protect from taxes that they don't have to pay, financial abuse, protecting themselves, protecting their families, protecting the inheritance for their kids, making sure, we hear this a lot, making sure things are as easy as possible. People will come in and I'm kind of fishing around trying to identify their goals, and they'll say, well, I just want to make sure, when my aunt died or when my mom died, it was just a mess and we had to do all this stuff. And how can I make it easier for my family? How can I make it easier for my loved ones? So we spend a lot of time talking through that, trying to make sure. And then there's a whole nother aspect of this planning, which is the incapacity portion. So what happens, and this was big during COVID, what happens if I become sick and I'm in the hospital and I'm on a ventilator, I can't communicate, who can make decisions for me? And if I'm in a coma, what are my preferences? Would I want to be kept alive indefinitely or not? So this is where we help people with the advanced directive for healthcare, so they can make these decisions and appoint their agent. On the financial side, the legal side, we help families with the power of attorney document so that they can name someone to handle really any financial, legal, business, contractual, anything I can do, you can do for me, is what I always tell people with the power of attorney. So those are kind of part of the package when we're sitting down with people and helping them plan for the future.
So what would you say would be the best age? I know this is a hard question, but the best age to start, or maybe not even age, but maybe the best stage in life to start estate planning?
It's a good question. It's a really easy one because I can answer like 18, which would surprise a lot of people. It's funny with those either getting closer to or young retiree clients, they often have young adult children who are not married yet. So one of the things that we talk about is when your kid turns 18, legally they're an adult. You do not have the right to their information. You do not have the right to make healthcare decisions for them if they're in an accident or incapacitated in that way. So at the very least, even an 18-year-old could have a power of attorney and a healthcare directive if they want to name their parent to make those decisions, which often they will until they settle down in their own life and they have a friend or a partner or a sibling who they want to do it at that time. So that always kind of surprises people. And especially in the special needs world, if you think about the special needs child, especially if there's a lot of medical issues or a lot of meeting with healthcare providers, therapists, as soon as that kid, doesn't matter if they have special needs, as soon as that kid turns 18, they're an adult and the provider can't talk to mom or dad anymore. So to the extent that that child is able to, signing those documents then is really important. And from there, like I said, it's always, for us, it's always major life changes that will bring people in. It's having the baby, it's the baby graduating, it's retiring, it's getting divorced, God forbid there's a death, and then, on into aging. Sometimes there will be an issue, we've downsized into a senior living community, or we've got a diagnosis of cognitive decline that we need to deal with. I think a good rule of thumb is to every 3 or 5 years, at least pull it out and take a look at what you've done and say, does this still make sense? And what's changed significantly? Do these people still make sense? But otherwise, yeah, unfortunately, a lot of young families, even with kids, don't get this done because none of us think anything bad's going to happen. And of course, we hope it won't, but it's such a heartache. It's such an ordeal for families with minor children if the worst happens. And there are a lot of things that people take for granted. Like, for example, I might think my spouse will inherit my property, but that's not what Georgia law says. If I die with minor children, they get some of that too. And it gets really complicated when you own your home with your spouse or when you own your home with your minor children. So lots of reasons to plan as early as possible.
Okay, well, that makes sense. And now I'll say, and maybe I shouldn't admit this, but I'm kind of guilty of, oh, all right, I've got my will that I, had drafted when my first child was born, and it's been, 15 years and I haven't done anything to update it. So, I mean, I think that's really good information.
Yeah,
and I would imagine a change in financial situation or circumstances would probably also warrant doing some updating as well.
Absolutely. From several angles. One might be just I had a great conversation with a new client this morning about what folks will sometimes refer to as generational wealth, which is, to the extent I am able to leave money for my children, what do I want that to look like?
Right.
I'm of the mindset that we develop purpose and value in life from contributing somehow to the world. And the fear is that if I leave millions of dollars to my children just outright without restriction, is that going to impede their ability to find that purpose and value in life? So definitely as the numbers tick up, those questions become more prominent. There can be some tax planning that's more relevant for higher net worth clients. The way property is owned and structured, we sometimes get into trust planning. A trust is an alternative to a will, where the mechanisms, the way that property ultimately passes to your loved ones, generally can be made easier, more straightforward. And I think the more moving parts we have, real estate owned here or there, business interests, the trust becomes more and more relevant as well.
Okay. And what about, a lot of people will say when it comes to estate planning, they'll say things like, well, I don't have anything, to leave to anybody. There's nothing for anybody to fight about. Is that a true statement?
Most people, now not everybody, but most people have something.
Okay.
And if you don't have something today, you might have something tomorrow. Even if it's your little old checking account, even if it's you've got a house and a checking account, even if it's not much, even if it's your car or your tangible personal property, things, the complication doesn't actually, or level of complication doesn't actually always correlate with the dollar amount. So
Okay.
I handled an estate. It was an awful experience, but a good learning one very, very early in my career where folks were fighting about household furniture. In the estate world, it doesn't necessarily need to be a lot of dollar value for people to have enough emotional connection to it to really make things difficult. And then the process can be difficult as well. In Georgia, if a minor child inherits more than $25,000, then they have to have a court appoint a conservator to take care of that money and follow really specific rules regarding how they can invest it, how they can use it. So by doing planning beforehand, we can avoid some of those technicalities that essentially just make life difficult.
And what about, I would imagine there are situations where there are multiple children. So, parent passes away and has 5 kids. And maybe parent assumes, well, you know what? They'll just split everything that I have 5 ways. I can tell you from what I've heard that it's not always that easy. And sometimes some or all of the kids have completely different goals and needs for that house. So is that another place where, estate planning is critical, even if all you have is a house and you've got multiple children?
Yeah, absolutely. When you are creating a will, one of the most important decisions you will make is who your executor is, who is in charge. If you don't have a will in this scenario, like one that you just described, that's one of the levels where the most fighting will occur. Who's going to be the administrator? Because the administrator gets to make a lot of decisions.
Okay.
So you got 5 kids, 1 house, you can easily see how there could be a dispute, and disputes mean time, money, headache, heartache. So the will absolutely is important, and you can have a third party. So if you have 5 children, but you don't think any of those 5 children are appropriate or capable of serving, or if they're all minor children, for example, I can name a professional, a banker, a trust company, or an attorney, or a CPA, someone outside of the family who's disinterested. So that's a huge one. But then also, when you are putting a will together, we're helping you decide how much authority you want that executor to have. So if I want to name Will, my son Will is going to be the executor. And I know that Will and Emma Claire might argue, but I trust Will to make the decision. I can put that in his hands and she can't say anything about it. So not that totally eliminates the opportunity for conflict, but at least you've eliminated the fighting over who's making decisions. I got into the show This Is Us on NBC, mostly when my husband would fall asleep because he wasn't interested. So I finally caught up and finished it. And there is this great scene towards the end of the series where the mother has been diagnosed with Alzheimer's disease. She has 3 grown children and has married, but their father passed away. So her husband is not their father. So that always creates interesting dynamics. But she makes a decision, and she's got 3 capable children. She just decides, I want it to be this one for this reason. And she sits down around the table and she tells them why. And I know, from my perspective, having dealt with numerous estates, and from the perspective of the attorneys who litigate in this area, that's kind of a golden rule is always, communicate as openly as you are comfortable communicating. So don't just say, I picked Will but I picked Will for this reason, and what Will says goes. And that's what mom wanted. I think when you take mom out of the equation or dad out of the equation, then that's when the kind of emotional backlog can bubble up. So anything we can do to prevent that and help families stay together is really valuable.
So, given that scenario, and I understand that in the show, there's a will, but I know that a lot of times people will do things like they'll say, "Oh, well, I told my son Will what I want, and he's going to make sure that everything goes the way that I want." But there's nothing in writing. So
Right.
Can you speak to what effect that had?
Yeah. Not a whole lot. It's a nice sentiment. That's pretty much it. When someone is formally appointed, named, and then appointed as executor under a will, they take on legal fiduciary duties. So by naming Will in my will as my executor, I've given him the authority, but he's accountable. He's accountable to the other beneficiaries. And he has to act in their best interest, and he has to take care of the property, and he has to make good decisions. He can't go sell that house to the next door neighbor for $10. Well, he could, but then he has breached his duty and his siblings can sue him. So that's kind of what keeps the fiduciary, the executor, on track, is that they're liable, they're responsible to the other beneficiaries. Versus if I say, well, I think he'll just do it. I'm not going to put it in writing. I told him what to do with the house. He can just do it. Well, he's not accountable to anyone. He has no obligation to do anything.
Okay. And then you're not sure that your wishes are going to be carried out if you're just verbally, telling somebody what your wishes are.
No, certainly not.
All right. So how does all of this impact a family that has an individual with special needs? Is there any different way to approach estate planning under those circumstances?
Sure. Just in terms of planning and goals, I think that shifts somewhat depending on the nature of the special need of the family member. And I think I've heard someone say, like, if you've met one person with special needs, you've met one person with special needs. Like, everyone is so different, just like in the typical population. That's the first thing we're kind of honing in on. One issue that becomes very relevant is eligibility for government benefits. So if I have a child who is a grown, an adult, who could otherwise inherit and manage property finances on their own, but that would interfere with their eligibility for Medicaid or supplemental security income, then I have to make sure they get that asset or that property in a trust that meets the requirements for a special needs trust. That way they can still benefit from the inheritance without losing those benefits. And the benefits could be providing long-term care, health care, therapies, community situations. So it can be a life-changing benefit that we don't want to lose. So that's a big one. And then another issue that comes up is just the individual's ability to ever take care of themselves physically or financially manage money for themselves. So even if benefits aren't necessarily on the table, we're asking, all right, is this a situation where he or she will never be able to manage money and should always have someone else in charge versus not? So that becomes very relevant as well. Special needs trusts are kind of the term of art. That's typically what we're putting together to make sure that, one, the asset's protected, we got the right person in charge of it, and it's not going to impact eligibility for government benefits. And there's different varieties and flavors, just like with anything we do, but that kind of sums it up.
And at what point in time would you recommend that a family consult with you or an estate planning attorney about a special needs trust, let's say for their almost 18-year-old child?
Mm-hmm. Yeah, I mean, the answer kind of gets back to the sooner the better. Even with a minor child, if something happened to mom or dad, then that could trigger eligibility for benefits that weren't there otherwise. So we typically want to start that planning when the child is young. And we do it in such a way that, just like with any estate planning matter, when circumstances change, things change in the laws, in their life, we can make updates as needed. And I see that a lot. I see people will come in with the binder that they had completed at their attorney's office 5 or 7 years ago. And we don't have the same people in play. We don't want that person as trustee anymore. We want to change this proportion, this amount. I've seen scenarios where the special needs child needs more. They need more to keep them afloat financially than maybe a typically functioning adult child who can support themselves. And I've seen it flipped, where because the special needs child situation is covered by Medicaid and supplemental security income benefits because of their living arrangement, and they don't need a whole lot more, then maybe it'll shift otherwise. So that becomes part of the equation as well.
Okay. And what about the family that says, I have a child with special needs or a young adult with special needs, but we don't have anything to go into the trust right now. So do we even need a trust?
Yeah. We want to go ahead and set it up so that if something happens, it's there to receive funds. It's not uncommon, and this is true with any family. It's not uncommon, especially for a young family who are still working and growing their wealth. There's not a lot to put in it now, but I might have a life insurance policy. So when I pass away, there's going to be, X dollars that doesn't really exist technically now, but if I pass away, then that'll be a huge amount that'll go into that trust. So we can create it so that the vehicle already exists and it pours over into that. So sometimes a trust will just be part of my will. So I'll say if Sarah Watchko passes away, then a trust is established. Or I might establish it now. It's not uncommon in a special needs family for grandma or grandpa or aunt or uncle want to leave something for the child. And if I go ahead and set the trust up now, then there's a vehicle for them to do that so that they don't impact government benefits either.
Understood. Okay. So that's great. And I'm glad you brought that up about other family members, particularly grandparents. I think a lot of times people forget that, hey, grandma has will written into her will.
Yeah, happens a lot. And I learned at some point to always ask, because one time we just did a will and that was fine. But a couple years later, she called back and she said, oh, well, my father wants to leave. And I was like, oh, well, now we need to go set up the vehicle so that he can do that. So I always like to, and sometimes people will say, look, we know for a fact and no one else is leaving little Jimmy any money. We go, okay, that's fine. Then we can do it this way. But always have to check.
And then, of course, you never know when something's going to happen to the parents. And so if they have life insurance, then you want to make sure that, the child isn't going to be excluded for benefits. So
absolutely.
Makes perfect sense. Well, thank you so much for explaining. I've learned a lot. For explaining some estate planning information. Is there anything else, like any tips, anything that you want to leave the audience with as they're thinking about estate planning now?
Yeah, I think I've hit on this a few times. One would be don't wait. And another would be don't do it yourself. There are resources out in the world, and I've seen it where someone did it properly through that, but that's not the norm. We spend a lot of time kind of cleaning up icky situations where it's a complicated area and these words have meaning. And so it's really hard to put a good plan together on paper when we don't know what all the words mean.
Right. And people's intentions. I mean, you've talked about, the fact that you will sit down and talk to the family about, okay, what do you want to have happen?
Right.
And if you're going to some document online, you're not going to get those questions, and it's not going to, kind of trigger those thoughts like, I never thought about this scenario.
Like me on WebMD trying to diagnose my headache. I should probably stay off.
Understood. It usually creates more problems doing that. So the same thing rings true with legal do-it-yourself type documents.
Yeah, at least in this case, it usually does.
Well, thank you so much for joining us.
Pleasure.
If you
Thanks for having me.
let the audience know how they can contact you if they have questions or want to consult or
Yeah.
want to get started with estate planning.
Absolutely. So our telephone number is 770-475-8041. So that's always a great way. Or you can find us on the web at www.estatelawga.com. That's ESTATE lawga.com.
And do you help families across the state of Georgia?
I do. Typically, it's in the metro area. We're located in a northern suburb, Alpharetta. So
Okay.
we get a lot of clients from this area, but especially with, the Zoom technology we discovered we were capable of using during the pandemic. Our geographic touch has certainly gotten a bit wider.
All right. Well, great. Thank you again so much for joining us. And we hope that you all have found this session very informative and that you'll take action on making sure that you have your estate planning documents in order. This has been the DisabiliTEA, and we will talk to you next time.
All right. Thank you.
You've been listening to the DisabiliTEA with Anjel Burgess. Thank you for your positive reviews, comments, and sharing the show with others. You can catch prior episodes at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more.